Okay, we'll call the meeting to order. We will seat Representative Groen for, who's missing? For Hatch. Looking for a motion on the minutes.
Second.
Motion by Ward, second by Schmidt. Any discussion? Seeing none, all those in favor?
Aye.
Any opposed? Anybody wish anything removed from the consent agenda? And a motion?
Second.
Motion by Schmidt, second by Lang. Any discussion? All those in favor?
Aye.
Any opposed?
Mr. Chairman,
Proposals to be postponed. I have two. Are there any other? And,
Mr. Chairman, both items will need waivers for Jelcar.
okay, so we need a motion for the Board of Licensing for Alcohol and Other Drug Use Professionals and for the Prescription Drug Affordability Board. We need a motion to postpone and grant waivers.
So move.
Second.
Motion by Schmidt, second by McGuire. Any discussion? All those in favor?
Aye.
Any opposed? Regular agenda, utility pole attachment rules.
Yes, sir. Let's see. So this proposal is implementing the One Touch Make Ready program, which is a requirement of the FCC. There are a number of legislative intent and some clarity comments. And there's also a recommendation regarding doing some legislation to fix some issues between the PUC and the department relative to their rulemaking authority. But they have filed a conditional approval, and that has been received, and a waiver as well. My apologies, but there's no FP memo on the website if you're looking for one. Just to summarize, there are some issues with some ambiguous terms. Pursuant to 541A1, rules must implement, interpret, or make specific a statute. And there are several places in this proposal in which there are some ambiguous terms that are used, but they are not defined. These terms are just, reasonable, non-discriminatory, and the phrase good and sufficient cause. If you note, the agency's cover letter indicates that one particular section of the rule, I think that was 1303.13, is meant to implement 47 CFR 1. And like I said, that's an FCC a federal program. The agency thinks that SB 88 from last session created a carve-out, but the statute clearly directs the agency to adopt the FCC's rules as the FCC has adopted them, but it also directs the agency to do so via the 541A. It doesn't explicitly carve out the rules from the requirements of 541A. So it's not clear whether or not that was intended to be an exemption. But the agency has noted that it's difficult to comply with both 541A and the FCC's rules. And that's kind of a high-level summary, if you will, of what's going on with the proposal. If you look, the first set of comments are on page 2 of the linked PDF down at the bottom of the page. And again, this is around this phrase or these sets of terms called just, reasonable, and non-discriminatory. So a pole owner is supposed to to provide terms of attachment that are just, reasonable, and non-discriminatory, but the agency hasn't defined those. There's no broad criteria to know what that means, and that can lead to arbitrary decision-making. So the agency has noted that everyone, the stakeholders and all know what these terms mean, but they still haven't defined them. I think the next comment is on the next set of comments are on page 7 and 8, and this pretty much is the same sort of comment. The rule again is saying that during the performance of make-ready work for good and sufficient cause, but it doesn't talk about what that means. The same issue on page 8, where they're using the terms reasonable opportunity and non-discriminatory basis. Again, we don't really know what that means. If someone's supposed to have a reasonable opportunity, is that one day? Is that 5 days? We don't know what that means. On the bottom of that page as well, you'll see that's on the bottom of page 8 of the linked PDF. There's a large comment box letting you know that section 13 of the rule for the One Touch Make Ready program, that is meant to be implementing that federal regulation. And like I said earlier, the agency thinks that SB 88 created a carve-out, but the language it doesn't state that. It says that the department shall, under rules under 541A, implement the provisions of One Touch Make Ready as adopted by the Federal Communications Commission, but it doesn't say that they're explicitly carved out from the requirements of 541A. So, and like I said earlier, the agency has indicated that it cannot comply with both. Same comment is essentially on page 10, where the rule is using reasonable opportunity or reasonably likely, but doesn't define what the term reasonably means. The last comment is a very large comment on page 11 of the proposal. And here we note that there's some need to clarify the rulemaking authority and the jurisdictional divide between the PUC and the Department of Energy. You may be aware that House Bill 2 from the budget bill from 2021 established the Department of Energy and transferred the PUC's functions, powers, and duties to the Department of Energy. Specifically, RSA 12P11 stated that all of the functions, powers, duties, records, personnel, and property of the PUC is replaced with the authority of the Department of Energy as of July 1st, 2021. And RSA 363(1) states that the PUC is an independent agency administratively attached to the Department of Energy pursuant to RSA 21G10. And so the chair of the PUC still has some powers set forth in 21G9, but 21G9 authorizes a commissioner of an agency to adopt rules of an agency. So it looks like that the PUC chair still has rulemaking authority, and we're not sure what the extent of that rulemaking authority is. We don't know where the line is between the Department of Energy and the PUC. So again, this comment is here to summarize some of the issues that we're seeing and that you may want to consider some legislation to address that. Regardless, the department interprets the statute to only authorize the PUC to regulate and enforce rates, charges, terms, and conditions of pole attachments, and to hear and resolve complaints. And so while there may be some lack of clarity where the jurisdiction exactly lies, it does appear that they do have authority to go ahead and move forward with this proposal. So that summarizes the issues with this proposal.
We have a request for public comment. Can Attorney Geiger? I don't know what you can say to polish this, but.
Thank you, Senator Reagan and members of the committee. I'm Susan Geiger. I'm from the law firm of Orrin Reno, and I represent the New England Connectivity and Telecommunications Association, or NECTA. NECTA has submitted a letter this morning in support of the letter that was submitted by the Department of Energy, which seeks conditional approval of the final proposal of the pole attachment rules. As indicated in our letter, we think that the information presented in Commissioner Chicoine's letter outlining the reasons why the statutory authority that DOE has allows it to maintain the wording of the rules that it has submitted is appropriate. And I'd be happy to answer any other questions that the committee might have. I'd also defer to Attorney Wiesner, who I believe is going to speak to this issue. He represents the Department of Energy.
Okay, so we'll hear from him to find out why there's so many comments on these rules.
Thank you.
Thank you, Susan.
Good morning, Mr. Chair, Madam Vice Chair, members of the committee. My name is Chris Elms. I'm the Deputy Commissioner of the New Hampshire Department of Energy, and I'm joined by Attorney David Wiesner, who's the legal director for the department. The final proposal and conditional approval request before you today are a result of the department's work to reflect the restructuring that occurred with the creation of the department in HB2 last year. This includes transferring many functions from the PUC to the department, including the rulemaking for utility pole attachments. We have made only minimal changes to most of the existing PUC 1300 rules that will now be the utility pole attachment rules of the department. The new Department of Energy rules are also intended to implement Senate Bill 88, which had many provisions dealing with broadband expansion. In that legislation, the General Court directed the department to adopt Federal Communications Commission's
Okay, so what are we going to do about all the comments about the vague words that you've
Yeah.
already known about and haven't done anything about it in the formulation of the rules?
I will let Attorney Wiesner respond to that.
Thank you. Excuse me. For the record, I'm David Wiesner. I'm the legal director with the Department of Energy, and I will address those issues. So earlier this week, we filed a conditional approval request. We addressed the editorial and formatting changes that were noted by OLS comments. We declined to make language changes, in particular with the language which has been called into question by the OLS comments. Again, as Deputy Commissioner Elms mentioned, our intent here was to make minimal changes to the PUC 1300 rules, which are effectively being brought over to the Department of Energy in connection with this rulemaking. And other than that change of name, if you will, from one agency to another, our focus was on implementation of Senate Bill 88 passed last year, which we interpret as directing the department to effectively adopt nearly verbatim the rules of the Federal Communications Commission regarding one-touch make-ready. We believe it's important to do that in order to affect the legislative intent to facilitate broadband expansion in the state by making it easier for new attaching entities to install fiber cable and other facilities on existing utility poles. And I will note that in our rulemaking process, there was almost unanimous support for adopting the FCC rules, nearly verbatim, as I say, in these state rules, consistent with that legislative intent in SB 88. So that was the decision that we made with respect to the new section 1303.13, which incorporates the one-touch make-ready rules into state rules. And the FCC rules, not constrained by some of the limitations that we see in the rulemaking manual here, include language such as reasonable and good faith. And so we incorporated that here. I've had this conversation with Attorney Reeve, and we discussed a potential language change that might be made in section 1303.01A, where there's a broad reference to terms that are just reasonable and non-discriminatory. And we do think that there would be an opportunity there to remove that language and merely reference the state statute, RSA 374-34-A. And if the committee would entertain that, I might offer that as an additional condition that might be considered for approval this morning. With respect to the other language that was called into question by the OLS comments, I will just offer that that language appears in the FCC rules, and in particular in reference to Section 1303.12, also appears in the existing PUC 1300 rules, which again we are just bringing over to the Department of Energy in this rulemaking process. I will add perhaps some nuance to Attorney Reeves' comments on 1303.13. I think in our view, it is not possible to both to accommodate the legislative intent to incorporate the one-touch make-ready rules of the FCC into these new Energy 1300 rules and comply with the rulemaking manual. Because the FCC rules, as I noted, contain the word reasonable in a number of places, and we carried that over. I think our view is that we would not be honoring the legislative intent to incorporate those provisions if we were to drop that language in strict compliance with the rulemaking manual. So I think our position is that this is a place where variance from the manual makes sense, because it is not possible to comply both with the manual and with the more specific legislative intent in SB 88 that we deem as requiring the department to adopt nearly verbatim those FCC specifications. And the FCC rules, I'll just note, are well understood by the regulated community as we understand it, most of whom are sophisticated telecommunications carriers, and you heard from one of their representatives this morning that they support the rules as proposed.
Representative McGuire.
Thank you, Mr. Chair. Attorney Wiesner, I'm curious how you interpret shall adopt rules under 541A implementing the provisions of One Touch Make Ready as adopted by the FCC as incorporate the federal rules into our rules.
Well, we believe the legislative intent was for those One Touch Make Ready rules as written by the FCC.
That's not what the statute says. It says adopt rules under 541A, implementing the provisions of the One Touch Make Ready rules. And I believe that in cases of question, without specific other legislative intent data, that's what it says. Implement the provisions.
Our view is that implementing the provisions without the word reasonable would not be implementing the provisions.
Thank you.
Go ahead.
Thank you, Mr. Chair. I guess this is a question for staff over there. It seems like our argument is around the word just, reasonable, non-discriminatory, and good and sufficient cause. Those phrases are repeated throughout the statute, throughout the rulemaking authority. And I guess my question is, absent a definition in the rule, aren't those, going back to my prosecutor days, those are pretty clearly defined legal definitions to begin with, that they're easily found and easily understood. And to follow up to Representative McGuire's question, if the FCC rule contained the word reasonable, how can our rule not contain the word reasonable if we're supposed to implement their rule? So I guess that's a twofold question. Is it seems like the legal definitions are clear. They've been adjudicated many times on those four different words or phrases. And secondarily, is if they did incorporate the exact rule, which would contain the word reasonable, we'd have the same problem. So I guess I'm struggling to understand why we would object to this.
Okay, so there are two different places. So one is the statute 374, and it does use some of these terms, just and non-discriminatory, and I believe it does use good and sufficient cause. I wouldn't say that just, reasonable, or non-discriminatory is well defined. It's certainly not defined in the statute. And so, as I said earlier, rules are supposed to make specific and implement and interpret the statute. So if the statute doesn't define it, then the rule needs to define it. what one attorney may think means reasonable, another attorney may disagree and think there's another definition for the word reasonable. It's pretty squishy generally. The second issue is on the word reasonable as found in the FCC. That also, I didn't see a definition in the federal statute for that. There could be one, but I didn't find one. So we typically, recommend, or we typically flag these sorts of words because they introduce ambiguity into the rule. Just like I said earlier, one attorney may think that reasonable opportunity is 5 days, another may think it's 10 days. So it's up really to the agency to define what that means when the statute doesn't define it. So I will point out that in the PUC proposal that the committee recently heard, they also use terms like just, reasonable, and for the public good. And we had some conversation with them about that, and they said that it was essentially in case law, and it was an adjudicative process, and so they did not feel comfortable defining that. So what they ended up doing was talking to the AG's office and then just referring back over to the statute. So in my conversation with the department, that was essentially what I recommended and what he's proposing with that first section or that first set of comments that you see on the bottom of page 2. So here, instead of using the terms just, reasonable, and non-discriminatory, they would just refer back over to 374-34A. So, I mean, that would somewhat deal with it. It still leaves it up in the air as far as exactly what that means. I could point out that if the stakeholders in the FCC, if everybody knows what these terms mean, then they should be able to kind of arrive at something, to define it. But it may be that there is some disagreement as to what those terms would mean, and they don't want to do that here in the rule. To get back to the other point I was making, the FCC rules are only in section 13, and that's some of the FCC requirements may be sprinkled throughout, but my understanding is that it's mostly in section 13 here, and that's where they're using some terms around reasonable. That section doesn't have those terms, just, public good, or non-discrimination in this particular section. Hopefully that answers the question.
Mr. Chairman,
Yes.
in response to Representative Lang's question, I would point out, in regards to making these comments, staff is statutorily obligated to raise any potential basis for objection. Committee can certainly disagree, or even if it thinks there is a basis for objection, under the law, you're not required to object.
Oh, so just to make sure I understand where we're sitting right now we have a conditional approval request. They've made some preliminary language changes that they based on the objections of staff in that first section. And that's what's presented and before us right now for a vote.
Yes.
Yes, and it sounds like so so they do have a conditional approval that that's on the table, and then they've also suggested some additional language in that first section, so it would be an amended conditional approval, assuming that the committee is in agreement with that language.
Subject.
I'm sorry?
Looking for an objection motion.
Mr. Chairman, since Representative Hatch is now in, Representative Gruen could be appointed for Senator Prentice, who is the only remaining member not here, regular member.
Okay. Okay with the chair.
Mr. Chair, I'm going to move to approve with the language suggestion number 1. To conditionally approve.
Representative McGuire.
Yes, thank you. Disregarding the other issues, I'm concerned that this doesn't seem to repeal the existing PUC rules, and I wonder if you would clarify that for us.
I believe that probably next month, the PUC will be before you with their amended version of the PUC 1300 rules, and that will remove all of these sections that appear here and retain for the PUC only the functions of dispute resolution and rate setting. So if you were to look at the existing PUC rules, I believe it's section 1304 will remain with the PUC and the definitions that go with it. Meanwhile, all of the other substantive provisions will be adopted by the Department of Energy through these rules. And it is our intent to see that those two sets of rules, our new rules and their amended rules, will become effective at the same time.
That would be good, having two sets of rules at the same, that were in effect would be inconvenient.
Representative McGuire, the notice number for that one is 2022-55. I have reviewed the initial proposal, and they do have comments, so they may be filing next month.
I'd prefer that we object to this and give them a month to hash out these language differences. So we have a motion on the table that I will be voting no on to approve the rule. So all those in favor? All those opposed? No. Okay. Motion by Schmidt to object, second by Hatch. Will they need a waiver? Or we,
They would, we would need a waiver.
okay,
No, wait a second, it's November.
it's
sorry.
November 28th, yeah. Okay. All those in favor? Aye. Any opposed? Thank you.
Thank you.
And next on the menu, Department of Agriculture feeding garbage to swine rules.
Thank you, Mr. Chair. So this particular rule, there was a conditional approval request filed within the time limits for this meeting. It was accepted and reviewed. On the website, there is a cover memo for the final proposal packet at the very bottom. We apologize that it's not with the conditional approval response on the website, but it is there at the bottom if anyone wanted to review that. But the remaining comments from the conditional approval request is one unclear legislative intent comment on page 3 and 2 notes to jail car. The first note to jail car is commenting on the fact that this statute has been in effect since 1995, and this is the first time that the agency is proposing rules for this particular section. The rules also comment on an application fee, which is statutorily set in RSA 43534 for a sum of $10. Additionally, for penalties reflected in RSA 43540, it does state that any person who violates the statute or rules, if there any, is guilty of a misdemeanor and may have an administrative fine no more than $5,000 levied against them by the commissioner. So the statute does also cover penalties without rules. With regard to the second note to jail car, it's just commenting that the agency does have the statutory authority to enter the premises of a licensee, which is reflected in the rules. The legislative intent, unclear comment on page 3, has to do with the special permits granted by the commissioner. The way the rule is currently written is that no swine-fed garbage that has not been properly cooked or treated shall be moved into or within New Hampshire unless pursuant to special permission granted in writing by the commissioner at the commissioner's sole discretion. This rule lacks criteria to outline what exactly is considered when a special permission is considered by the commissioner and what criteria the commissioner will make that decision on, which leaves room for oral rulemaking, which is prohibited by RSA 541A1. I have had some discussions with the agency about specific criteria. The agency believes that in the communications I've had with the agency, they have voiced that they believe that having criteria would be too, that the criteria considered is too broad to actually be put into rules. However, there was some back and forth discussion about potential language that could be used as criteria, but no amended conditional approval request was received. So at this time, that comment is still standing.
Doctor, talk to us. You turn it on.
Thank you. Steve Crawford, State Veterinarian, New Hampshire Department of Agriculture, Markets and Food. Good morning. So the summary that you heard was accurate. There were a couple of substantive comments earlier. We yielded on one because we did not believe that there would be any emergent implications to approving other forms of treating garbage. In this particular instance, though, the department thinks that just-in-time disease control flexibility is necessary. And we also think it's already allowed in statute. There are a couple of pieces of statute that we believe cover the same thing that is proposed in that 405B. So interstate quarantine management decisions are authorized under 436.35. That section actually uses may 3 times, doesn't use shall. So I believe we have that flexibility already. And we've seen with the high path avian influenza stuff we've been dealing with this year that just-in-time changes are kind of important for us to be able to make the right decision rather than having to go through an emergency rulemaking session. So we're open to finding the language that maintains that latitude for the commissioner to make just-in-time disease control decisions. And with, again, conditional approval is what we're seeking.
So does staff believe that you can come to an agreement on the language?
Well, Mr. Chair, the agency did send an email with some language that could potentially be turned into a rule. In my opinion, specifically that special permission shall be granted when animal disease risks. I apologize. Special permission shall be granted in the most efficient, expedient, and effective way possible. We're still working on that language to get that in a place where it would be specific enough for criteria, but also broad enough to allow the agency some discretion to deal with those time-sensitive issues. So it is possible that we could come to an agreement on that.
Go ahead.
Yes, thank you. Dr. Crawford, how often does this come up? Is this a common practice?
The asking broadly about garbage feeding or asking specifically about this interstate movement permissions? Both. Garbage feeding is a common practice. It's been authorized under federal statute since the mid-'80s. And as you heard, the department has never sought to implement rules because the statute doesn't require us to have rules. It authorizes the commissioner to have them when we think it's appropriate. We have seen over the last several years, and USDA has always done those inspections for us. We have seen over the last several years USDA pulling back its resource allocation to the state. So we think it's appropriate. The timing was appropriate for us to have our own rules set. In terms of management of interstate quarantines, several times a year, probably. More in the last year with high path avian influenza, but several times a year we're making these types of decisions about how to deal with something during a quarantine.
So several times a year, someone wishes to move garbage-fed swine out of New Hampshire, you won't care. It's into New Hampshire that's the issue.
I guess my apologies. I was thinking quarantines broadly, not just quarantines related to this. Quarantines related to this, I don't recall the last time a quarantine related to garbage-fed swine has come up, but other livestock that we have authority over several times a year. Sorry.
Okay, so if I understand you correctly, the special permission in writing is extremely rare.
Yes, ma'am.
Thank you.
Got a motion?
Second.
Motion by Hatch, second by McGuire, to conditionally approve and encourage your consultation with the staff.
Understood.
Any discussion? All those in favor?
Aye.
Any opposed? Thank you.
Thank you.
Liquor Commission Employee Incentive Program.
Hey, so this set of rules would implement an employee incentive program in which employees can get, monetary incentive for sales. There's only one issue to talk about in regards to these rules, and you'll see that on the first page of the rule set, which is on page 4, the linked PDF. So HB 2 in 2011 established that the agency may develop and implement an employee incentive program, and it required the agency to implement that program via rules adopted through 541A. So this is the first time that the agency has done any rules for this program. In response to OLS comment about implementing the rules or implementing the program prior to adopting the rules, the agency has indicated that they have not implemented the program at all. The committee may have some questions about that.
Questions? Are you here from the Liquor Commission?
I am.
I see. Okay.
Good morning. My name is James Vara. I am COO of the Liquor Commission. Prior to that, when they were submitted, I was Chief Legal Counsel. If there are any questions, I'm certainly willing to answer them. I can say and just concur that at the time, and I should say before I begin, I'm dealing with some hearing issues, so if I have to ask questions again, I apologize
Fine.
to the group.
Right.
This is the first time that the Commission has sought to implement the program, of which we're now asking for rules to occur before that. So we've not started the program. We're coming here as we're statutorily required to ask for rules happen.
Questions? Seeing none, motion.
Move to approve.
Second.
Motion by McGuire, second by Lang to approve. Any discussion? All those in favor? Any opposed? Thank you.
Thank you.
Keno at Lottery Retailers.
Thank you, Mr. Chair. This particular proposal, we also received a conditional approval request for. The conditional approval request did address a number of editorial comments and a couple substantive comments. However, there are a number of remaining comments, primarily due to statutory conflicts as well as statutory interpretation. Looking at the conditional approval request, the first comment is a note to jail car on page 1 regarding the license requirements for a retailer to operate Keno on their premises. The rules reflect RSA 284-46-3 with regard to criminal convictions, specifically stating no person who has been convicted of a felony or Class A misdemeanor within the previous 10 years, which has not been annulled by a court, or Class B misdemeanor within the past 5 years, which has not been annulled by a court or has violated any of the statutes or rules governing charitable gambling in the past in this or any state shall be licensed to under the subdivision. This statute is in conflict with RSA 284-45-5B, which also prohibits an employee to operate Keno games if such person has been convicted of a felony within the previous 10 years. However, it does not mention Class A misdemeanors or Class B misdemeanors, but rather a misdemeanor involving falsehood or dishonesty. So there may be a need for a legislative change with regard to those statutes to make them more consistent. But at this time, the commission is using the more restrictive statute with regard to that. The second comment is an authority comment. At the bottom of page 1, the rules specifically state that the applicant shall have the ability to meet financial obligations as demonstrated by an established credit history or a bond. Neither of these requirements are reflected in statute. There is a statute with regard to the commission being able to ask for financial information after someone has been licensed to operate a Keno machine. However, there is nothing in the statutes regarding their ability to do this when an applicant is applying for this license. So there is a bit of a potential issue with regard to their authority to do that. The third comment on page 2 has to do with the reference to the license, the applicant to sign a agreement called the New Hampshire Lottery Uniform Retailer Agreement, excuse me. This agreement, which was submitted to our office, primarily is made up of requirements that are uniformly applied to all retailers. Under RSA 541A(4), this would be considered a rule. However, the committee has taken varied positions on this interpretation when reviewing contracts like this one in the past. For example, this agreement also touches on the sale of lottery tickets and has actually been in effect under the Lot 300 rules. However, these are new rules, and they have included provisions for Keno machines specifically. So I think it's worth taking another look at it to consider whether or not these requirements should be placed in the rule, or if the committee would just determine it as a contract. But regarding the agreement, there are also two issues with the agreement itself, which I will touch on later with regard to two provisions in the agreement which the commission may not have the authority to require. The next comment is on page 4. It's an edit unclear comment about the applicant losing his, what requirements the applicant may lose their license. There are two statutory provisions of which the applicant can have their license revoked, which are not reflected in the rules. The first is whether or not they lose their liquor license after submitting the application, as one of the requirements for being able to operate a Keno machine is to either have a liquor license or to sell lottery tickets on the premises. The other is with regard to the criminal convictions, whether or not someone has those criminal convictions. And as I stated, there are conflicting statutes with regard to what those requirements actually are. With regard to the next comment on page 5, it's an unclear comment. I apologize. Underneath that, there's a authority legislative intent comment with regard to another reason that the licensee can have their license revoked. The commission specifically put in the conditional approval request that if a licensee fails to comply with the terms of the agreement, including failure to meet the minimum sales requirement, that could be grounds for revoking the license. However, there doesn't seem to be anything in the statute requiring that a licensee meet a minimum sales requirement. On page 2 of the agreement, there is a note that the licensee would be agreeing to meet a minimum sales volume of $3,400 per week in Keno sales. And as I stated, there's nothing in the statute that specifically requires that of a person who has a license to operate a Keno machine. So there is an issue with regard to that particular provision. The other issue with regard to the agreement is found on page 6 of the agreement. It says to have the Keno 603 terminal available and operational for the sale of Keno tickets and to redeem all Keno tickets during all hours and days that the retailer's business is open. RSA 248.47(1) specifically states that a person can only operate a Keno machine between the hours of 11 a.m. and 1 a.m. So that agreement may be in conflict with the statute if a retailer has hours that they're operating outside of that statutory requirement. On page 5 of the rules, there is another unclear comment regarding hearings. The commission specifically cites RSA 28450 or RSA 541A30, 3 as applicable for a licensee who is requesting a hearing. There's an editorial comment that should be citing to RSA 541A32. But additionally, RSA 28450 specifically refers to rehearings and does not refer to initial hearings, and also states that the rehearing shall be governed by 541, which is the statute which allows appeals to go to the Supreme Court. Under this rule, the licensee should be entitled to a hearing and then a rehearing within the commission prior to be able to appeal to the Supreme Court, as the Supreme Court is likely not to take up an appeal that is not exhaustive all administrative remedies. So this rule is a bit unclear as written. It seems as though they need to have a cite to either their procedural rules for hearings or a different statutory cite. Also on page 5, there's an unclear legislative intent comment, once again commenting on the conflicting statutes with regard to the criminal history.
So do you have hopes that on a conditional approval that you can get all of this squared away?
So I apologize if I didn't make that clear. This is on a conditional approval, and as I stated, the conditional approval did address some of the substantive and editorial comments. However, with regard to the statutory conflicts, that's something that obviously would have to go to the legislator to change. And with regard to the agreement, it does seem as though that agreement is necessary for the commission to operate, rent out their machines, have their machines maintenance and all that. So there are certain provisions in there that the committee should consider when, whether or not the agreement can stand on its own or whether or not it can be incorporated to rules. Those are issues that really can't be addressed just between OLS and.
So let's hear from the
Committee.
agency and tell us your plan for rectifying.
Good morning. My name is Valerie King. I'm with New Hampshire Lottery, and I'm here with me is my superior, John Conforti. He is the Chief Compliance Officer with New Hampshire Lottery. I'm going to let John deal with some of the bigger issues.
So thank you, Mr. Chair. So we've addressed, I believe, a number of the comments that Attorney Ricard has brought up. There are a few that we can address because they're statutory in nature. The underlying statute itself has some conflicts. We have agreed, and we do plan to work with the legislature in this session to address those issues. That's in particular with respect to the criminal background requirements for licensure.
So who in the legislature are you dealing with?
I'll have to speak with Director McIntyre. I believe we are going to look at actually removing the license fee as well. And I don't know if Representative Lang, if we've had discussions with you yet. I know we have some ongoing discussions with members of the legislature to get those ready for this session. But I don't know who specifically Director McIntyre is working with, but I know that is underway.
Can you get back to us on that?
Absolutely. With respect to the issue of asking for financial information on the front end, as we said as we discussed with staff, RSA 28446 allows the Lottery Commission to review an application and either approve or deny it. 28446 identifies very specific reasons why we can deny an application, but it does not mandate that we shall accept an application under all circumstances. And we interpret that to allow the commission to require some evidence of ability to operate effectively that is based on the statutory requirements. So as Attorney Ricard said, there are a number of financial requirements that are on a licensee during the terms of operation. What we have done as an agency is request, as part of the application review process, that they demonstrate evidence of financial responsibility. Obviously, this is very important to the commission because a retailer is effectively retailing the state's product. They hold our money after a sale and before it gets paid to us on a weekly basis. So it's critically important to us that obviously that these entities are financially responsible, and we believe that that is based on statutory authority that the legislature has given us in 284-48 that requires a number of financial reports and financial requirements for licensees during the course of operation.
And I'm sorry if I could just step in very briefly, and I apologize for not bringing this up before. This comment was also made on the conditional approval text from 2017, and at that time, the committee did approve the language at that time.
And I should have started with this, that and we discussed this with Attorney Ricard. We're bringing these rules forward because the legislature changed to expand the eligibility of Keno licensing to retail environments. And that's literally the only changes that have occurred. All the remaining changes that staff has brought up that, obviously need to be addressed, were underlying in the rule since 2017. So this was a minor modification that obviously has brought up, staff obviously has identified a number of issues that need to be addressed. With respect to the retailer agreement, we do have what is essentially a retailer contract that addresses all elements of lottery sales, and Keno is part of that. We would suggest and would ask that the committee allow this to stand outside of rules because obviously this is in the nature of a business agreement between a retailer and the lottery as the wholesaler of these lottery products. And we need to be able to address issues that come up in the course of business quickly. And we obviously, they are subject to your review because they are referenced in here. However, we do need some level, I think, of ability to make changes as business conditions require on a faster basis. And that's why we're asking that that agreement remain outside of the rule, but only referenced in the rule so that we're able to change those as would be required on a more expedited basis.
You might want to consider that when you're doing your legislative changes. Go ahead.
Thank you, Mr. Chair. I have one question. The statute limits the hours of operation for Keno, and this seems to imply that it can be played at the local convenience store 24 hours a day.
Yes, thank you, Representative McGuire. I meant to bring that up on my initial discussion. So Attorney Ricard is correct. However, the Lottery Commission controls the game, the hours of the game. The game is only available between 11 and 1 a.m. The reference to allowing operation during all hours, we allow the sale of tickets for example, it is 9:55. We would allow someone to buy a ticket for the first draw, but the draw only occurs at 11 a.m. And that is wholly controlled by the Lottery Commission. So the availability of the equipment to sell is to sell for games that will occur only during those hours and to redeem tickets that have already won. So I understand theoretically there's a conflict, but in reality, we have complete control over that game. They are not operating the game. The Lottery Commission operates the game. They merely make it available through terminals in their locations.
Tim?
Thank you, Mr. Chair. Just considering it was my bill, House Bill 355, that created a little bit of this mess, I'll be happy to take responsibility for cleaning it up.
Questions from the committee?
Mr. Chair, I'm sorry, just on the point of time of sale, why can that not be put into the rules for Keno expressly? I understand the system. I understand you control when they can and cannot be sold, but shouldn't that be stated?
Certainly, we can take that back and revise that. I wanted to point out for the committee that that is not allowing licensees to sell outside of the statutory approved period because sales are only permitted through the lottery during that time period. However, we can make that editorial change.
I think that's very important as part of the conditional approval to do that. Thank you, Mr. Chair. Thank you.
Peter?
Thank you, Mr. Chair. So your earlier remarks with regard to being allowed to operate outside the rules with regard to exigencies of business practices and so forth, that is an awfully wide open door, it seems to me, for for oral rulemaking and so forth. And I'm a little bit curious about how we're going to. Once you're operating outside the rules, basically do anything you want with that star of business requirements and so forth, unless you can confirm that it's not nearly as loosey-goosey as it sounds.
So, Representative Schmidt, it's not nearly as loosey-goosey as it sounds, because it is referenced in the rule. It remains subject to your purview. I'll let my rules expert explain exactly the benefits that we would have, but you would certainly still have oversight over that process.
So I assume you're referring to the agreement?
The retailer agreement.
Retailer agreement. So that is incorporated as part of the rule, and it is part of your package, and it lays out what they can and cannot do. So I'm not sure.
But I think so I believe what you're asking is it would go through a more expedited process in order to change the agreement. So we would not have to go through a full rulemaking process, but you would still have oversight. JLCAR would still have oversight over that process.
Thank you. That really helps.
Mr. Chair, I move conditional approval.
In a second. Get to that. Go ahead.
Regarding the agreement, if you feel that it's a contract and it's outside rulemaking, then that's fine. But if you consider it to be a rule, then they can't incorporate it by reference. In fact, this agreement seems to be created, and please correct me if I'm wrong, by the Lottery Commission. And you cannot incorporate by reference a document that's created by or on behalf of an agency. But if you consider it a contract, then it's not an issue.
Mr. Chair, question? So considering it as a contract versus a rule in this context, that contract, I assume, is still subject to oversight by the commission. So the Lottery Commission itself, if there was a change in its contract, would have to approve that. So it goes through another process besides JLCAR to adjust any changes. Is that correct?
That's true. It would go through commission, and we have always, I understand staff's comment, but we have always brought any changes to that document because it is referenced in numerous rules. So anytime we have edited that agreement, we have brought it before this committee.
It's also dated. It's referenced by date in the rule.
Okay. Any other questions? We have a motion and a second.
I just wanted to add that with regard to the references for hearings, I can make that correction as part of the conditional. I can reference our LOT rules that oversee hearings and make the correction to the RSA, I think it's 541, that's in the rule.
Any further discussion? Seeing none, all those in favor of the conditional approval? Aye. Any opposed? Thank you.
Thank you.
I apologize, Mr. Chair. Who seconded that motion? Thank you.
Prescription Drug Affordability Board.
That has been postponed, sir.
Okay. And the Midwifery Council.
So, Mr. Chair, This is another rule that we did receive a conditional approval request on. It did address pretty much all of staff's comments except for one substantive comment on page 1, mid 401.01L, the definition for significant morbidity. It's unclear how it's written. It's actually very confusing. We had multiple discussions and none of us could really figure out what it meant. So I have been having numerous communications with with Ms. Kelly regarding the definition, and we have worked on a potential compromise for this. The only problem is that the Midwifery Council has already met this month. They're not meeting in November. They won't meet again till December, and this is something that would have to be run by them prior to the change being made. So at this time, the options of the committee would be to either approve the conditional approval as it's written, do a preliminary objection, for which time the council would have the opportunity to do a response with regard to fixing that, or postponing this item, though if it's postponed, it will need a waiver.
Mr. Chair, there is one other option. That is if the committee initially approved it with the change requested, but with the realization that the board might not agree with the language that's been worked out between Tina Kelly and staff, in which case, if they chose not to approve it, then it would become a preliminary objection.
That seems to be the correct route. So preliminary objection.
Okay. Representative Hatch moves the suggestion of the staff to conditionally approve. We have a second.
Second.
Second by McGuire.
I think I objected.
Any discussion?
And the motion would include the language that was discussed.
Yes.
With all,
Yes, with all staff comments.
yeah.
All those in favor?
Aye.
Any opposed? And OPLC, electrologists.
Hey, so these rules are on electrologist and electrology schools and their licensing requirements. On September 16th, the committee voted to enter a preliminary objection based on staff comments, and as part of that vote, included a request that the agency provide a report on the mechanisms to fund activities during the rule's expiration. So what you have in front of you is the objection response and also a cover letter. We have a couple of comments on the cover letter as well. The agency did not address all of the staff comments and also has substantively amended the rule, but not in response to OLS comments. Additionally, the agency hasn't provided a report of mechanisms to fund expenditures during the entire time that the rule has been expired, and the rule has been expired since 2017. So that's at a high level what's going on with the request. If you look on page 2 of the cover letter, you'll see a large comment at the top of the page. OLS, we had commented previously on the fact that the rule didn't have forms for electrology schools to fill out, and noted that there was also no address in the rule for individuals to submit their required information for licensing. The rule also stipulates that the applicant's signature constitutes a certification on the information that they're going to submit, but there's nothing for a person to know that the sheet of paper that they sign is going to be their certification. So the agency's response hasn't resolved that issue. The agency created 2 checklists and states that creating forms wouldn't be a good way to expend their resources. So despite the fact that the checklists don't contain a blank space for the applicant to sign, there is still some concern that that the applicant isn't on notice, that their signature is going to constitute a certification, and that the checklist may be a type of form because it is asking for confirmation that certain things have been done by the applicant. If you look on page 3 of the linked PDF, you'll see this is a cover letter from the OPLC, in which that last paragraph there, they address the fees that they have collected for this past year. But as we noted, the agency statement doesn't address the collection of fees since the rule expired in 2017. Now, these rules were over at HHS, and then the laws of 2015 via House Bill 2, which was effective in 2015, transferred that authority over to the OPLC, and then the rules expired in 2017. But let's see. The next comment is on page 5 of the objection response. Here, we had requested that the agency delete this phrase "for the purposes of this chapter" in 2 different definitions. We had initially made this as an editorial comment, and the agency said that they did not want to take this out because it's more clear. But yet having this language in these 2 definitions kind of makes the other definitions unclear, whether or not they actually apply to the entire chapter or not, because you're differentiating 2 definitions and you're saying these 2 definitions apply to the entire chapter. So that was the reason why we raised that concern. So that concern is still present. The other,
May I interject? on
yeah, go ahead.
that? And the location of the definitions, they're at the beginning of chapter 700. That automatically means they're applicable to the entire chapter. So the language is superfluous to say for purposes of this chapter.
So I'll skip the comments that were editorial in nature that weren't addressed just to save time. The next comment, I'm just scrolling down here, is on page 20 of the PDF. You'll see that the agency has inserted some new language that's not in response to our comment. You may have some questions about that. We do note that the first couple of changes there are most likely editorial, but the other 2 are not. They're new language. The next comment, I'm just scrolling down, is on page 25 of the PDF. The agency doesn't want to change the language here to shall. It says will not. The language says the executive director shall notify the applicant or licensee as applicable of deficiencies and explain that the office will not approve unless the deficiencies are corrected. The agency states that this isn't a requirement, and so it shouldn't be a shall. But the very next section says if approval is denied pursuant to B above, it makes it pretty clear that that's going to be a shall. If there are deficiencies, then they won't be approved. So that language really ought to be shall. Then let's see. Like I said, I'm going to skip the editorial ones. The next one is on the next page, 26, the bottom of the page. This section is where we begin to see the insertion of a checklist. And like we said before, it's not clear, in what manner or how or where an applicant is supposed to submit this stuff. OPLC staff did indicate in the last meeting that they were going to insert an address either into a form or into the rule, but that hasn't happened. So neither of these checklists tell individuals how to submit the required information. It doesn't provide any kind of contact information or address. So that's one issue. And then if you look on the next page, again, the owner's signature on the request shall constitute certification. So again, this hasn't resolved the issue of a person having notice that what they're signing, be it a piece of paper or something, that constitutes a certification. And that's the same issues again on page 28 and on page 29. Also on page 29, there are some new language that wasn't in response to comment that we note as well. let me skim through. I think that those are all the issues.
Thank you, Mr. Chair. For the record, Lindsay Courtney, I'm the Executive Director of the Office of Professional Licensure and Certification. Before I get into the specific comments, I just wanted to give you a high-level overview of how we ended up here with expired rules for several years. Obviously, the committee is aware that the Electrology Advisory Committee transferred from DHHS to OPLC, I believe, in 2018 via House Bill 2. At that time, and for several years thereafter, the committee, while advisory in nature, was essentially functioning as an actual committee with complete regulatory authority. That had been the practice. There had been deference given to committee members in terms of moving things along and making rule changes. There was a disagreement between the agency and the advisory committee members as to how to handle practical examinations, which is why at that time the rules were not moved forward. Fast forward to 2020, the agency has had a change of practice in theory as it relates to advisory committees, and worked to obtain statutory changes, which we did this past year regarding the administration of practical exams. And that's why now, notwithstanding a disagreement between the advisory committee and OPLC, we moved these rules forward. With respect to the first issue regarding fees, I think we have addressed the committee's concerns. While the rules have been expired since 2017, the fee was actually set forth in statute. We did have clear statutory authority to collect fees until July 1 of this year, when we worked with the legislature to remove all statutory fees. Since July 1 of this year, we have not collected a single fee regarding electrology. There are only approximately 60 electrologists, so the fact that we haven't collected that $110 biennial fee is not breaking the bank. We are working with the committee established by Senate Bill 230 to clarify, or 330 to clarify OPLC's fee setting authority, and I do anticipate bringing some rules forward in the 1002s that'll just collectively address the fee setting issue. Until that time, we will be able to pay our bills, particularly given the fact that the agency historically lapses significant sums of money to the general fund. Regarding the substantive changes, I would disagree that any changes that we've made are substantive. The bulk of the comments that we received from OLS were centered on not providing sufficient clarification or notice to the licensees. Any of the changes, including the changes I think referenced on page 20, are editorial in nature in order to provide clarification in response to the consensus that we received for the OLS comments. Regarding on page 5, for purposes of this chapter, I'm happy to eliminate that. I disagree that it creates an issue of substance. I do think it's editorial in nature, but for our purposes, I'm happy to eliminate that if that is the committee's desire. Regarding page 26 and the checklist, in practice, we have never had a mechanism for a school that's not accredited to apply to be an approved school. That's just not something that occurs. However, as part of establishing our internal controls, we became aware that we have a statutory obligation to have a mechanism apart from relying on accreditation to have a pathway for someone to apply. I would be 99.9% sure that nobody will ever exercise that option with the 60 electrologists that we have and the approved schools that already exist. Additionally, accreditation is where electrologists receive a lot of their continuing education and their information they need to actually perform their job. So I'm happy to create a form, but with one staff person focusing on agency rules and the need to update a lot of the agency rules to be reflective of our statutory obligations, I do not think it's the best use of staff resource time. If the committee disagrees, we are happy to go back and create a form. On the checklist issue, I would note that there is a clear direction as to what one needs to do in order to apply. There is an address listed on the checklist. Additionally, and I know that the committee may not be aware of this, but OPLC is trying to finalize all of its rules in draft form. And one of the draft sets that we will be filing, hopefully shortly, will be the PLC 300s. And those will be the licensing procedures, not only for OPLC, but for all of the boards. It has taken us a little bit longer to obtain comments from stakeholders and feedback than we had thought. So I had anticipated that those would be before you in some fashion prior to conclusion of the PLC 700s. That will address more specifically and discreetly how all applications have to be filed. So from a practical standpoint, I think that that will address the issue. That said, there is an address on the checklist. And then finally, I did want to note that there was a comment from OLS regarding the agency's desire to not incorporate forms into the rules, but rather to specify the application requirements in the rule. And I understand that there is an expedited way to modify a rule that's incorporated by reference, and that may be beneficial if there needs to be some changes. But as the committee is aware, there has been a historic lack of internal controls at the agency and at the board level. And what I have observed is that for many years, board staff have changed and modified forms that they were not allowed to do so, to the point that it was unclear what form was actually approved by JLCAR, and we had to go to archives. As a result of that, until we have finished our profiling project that I've talked about previously, as well as establishing internal controls, I have requested that all requirements be placed in rule, because that gives us an opportunity to confirm that the application we are sending to individuals or putting on our website is actually what is statutorily and legally required of us to ask. So that would be the response to that OLS comment. Once we feel satisfied that we have internal controls in place, maybe we can move in a different direction, but it's not at this time. Thank you.
If I could just follow up real quick. So there is an address in the header of the checklist, but there's nothing that affirmatively tells the applicant that they should send it there or to send it to the board directly. I would take issue with the comment that some of these amendments are editorial. They are not. For instance, on page 27, there's an entire new sentence. So I wouldn't think that that's an editorial. The agency may view it as cleanup, but it certainly is a brand new sentence. There are other places that are like that as well. Let's see, there was, as far as, I'm not sure what statutory authority the OPLC is relying on as far as the fees are concerned. Like we said at the outset, the paragraph on page 3 of the cover letter only talks about the collection of fees for the past year. It doesn't talk about the collection of fees during the rules expiration. I'm not sure what authority they would have been, collecting those fees under, and I don't see it referenced in the cover letter.
If I may.
That was addressed.
I agree that there was statutory authority that was repealed as of a year ago.
Okay, what's the recommended action by the staff?
Well, you could request a revised preliminary objection. It sounds like the agency is willing to take out or to change some of the language. For instance, the language for this chapter and the definitions. The agency has noted a few times in testimony that they're willing to do a form instead of checklist. So you may want to give them time to be able to do that.
So move.
Second.
Motion.
Second.
Mr. Chairman,
Yes.
for a revised objection, the agency has to make a request of the committee.
I would think that their comments that they're willing to make these changes amounts to a request, and I would move we accept that request.
Lindsay,
I make the request consistent with the committee's discussion.
thank you. Discussion? We have a motion and a second. All those in favor?
Aye.
Any objections? Thank you. And to wrap up the day, the Department of Revenue Administration.
Thank you, Mr. Chair. Starting with 2022-104, this role, all three of the roles, but this one specifically had been brought before the committee previously and has been reworked a couple of times. At this point, the only comments remaining are some inconsistencies between the rule and the forms that were submitted to OLS. I have talked with Attorney Wong regarding those inconsistencies, and he has explained that the forms are actually edited and changed and posted by a third-party vendor. So the agency's plan was to revise the rules, get the rules approved first before going to the vendor and having the vendor make those changes on the forms. The agency is also exempted under RSA 541A. Their forms are exempted from the rulemaking process, so having them change their forms outside of this process wouldn't violate any statutes at this time. With regard to the note on page 27, that form was eventually submitted to OLS. The comment on page 28, once again, it's an inconsistency between the form and the rule. This one was specifically noted because it had to do with the certification. In the rule, this certification stated that it had to be done by the majority of the governing board or their authorized designee, while the form stated that it was the finance director or city manager that would certify the form. In discussion with the agency, they did state that they would change the form to reflect the rule language, as they plan to do with their other forms. The other comment on page 28, once again, was specifically noted because of the certification not being submitted with the form. So OLS was unable to see that certification. In conversations with the agency, it appears that that form, it's an online form that when you submit the information, after you complete the form, submit the information, then the certification page pops up. So that's why it was not submitted to OLS. I have not seen that certification page, as it seems difficult for the agency to provide it because of that technological nuance, but that was all the remaining comments on this rule.
Yes.
Move to approve.
Discussion? Seeing none, all those in favor? Any opposed? Next.
With regard to 2022-114, once again, this is one that has been before the committee before. It was sent back. Work has been done to it, so that the only two remaining issues were, there are a couple comments starting on page 2 regarding the authority legislative intent for the agency to seek or to request people submitting their forms sign under the pains of penalties of perjury, as it's not authorized by their statute. The agency has stated to staff that they are going to be seeking a legislative change, specifically to RSA 21J1(2) by adding a new subparagraph D, and Attorney Wong can correct me if this is not being stated correctly, but the language that they're proposing is developing such forms or returns as may be necessary, which forms or returns may be required to be signed under the pains and penalties of perjury. Staff's opinion on that language is it would be sufficient to address this issue. The other remaining comment on this rule is on page 4. It's the unclear comment with regard to the agency's use of the word sufficient. A amended conditional approval request was submitted to our office reflecting change to this language. Specifically, they would change sufficient number of to enough, so that the statute, the rule says enough stamps purchased within the previous 90 days to pay the tax due on cigarettes and little cigars present on the premises at any given time. Changing that language, in staff's opinion, would address our comment. But if the committee has any additional questions or wants to further explore that language, that would be something staff would be fine with.
Go ahead.
Move to approve with the addendum that the agency seek legislative clarification.
Discussion? All those in favor? Any opposed? And equalization of assessment for cities, towns, unincorporated towns, and unorganized places.
So staff also received a conditional approval request to address the comments, and there was really only one comment with regard to this rule, and that is the incorporation of the equalization manual into the rule. Staff's comment was an authority legislative intent comment because there was a change in which board was actually preparing that equalization manual and who, on behalf of who they were creating that manual. So at this time, it was in the opinion of staff that the particular board was doing it on behalf of the agency. It was administratively tied to the agency, and therefore the manual should be or could not be incorporated by reference, but had to be included in the rules. After looking at the conditional approval request, it seems as though that would not be such an easy thing. And between discussions between the agency and staff, the better route to potentially take is for the agency to instead seek a legislative change to exempt the manual from having to be incorporated in the rules. So exempting it from RSA 541A. And after discussion with the chair and vice chair, it was determined that that may be the better approach, in that the conditional approval request be denied at this time and that the final proposal be voted on with one minor change requested by the agency regarding Rev 2803.03B. The agency just asked that that particular sentence be changed to the department shall use the weighted mean ratio calculated to 1/10 of 1%, and then deleting if the weighted mean ratio with a 90% confidence interval does not straddle 1.00. This is not a huge substantive change and would not really affect the final proposal. So staff didn't have any comments with regard to that agency, that suggestion by the agency.
Yes, I recommend we conditionally approve the final proposal with that change, and request the agency to request a legislative change to incorporate the manual by reference.
Discussion? All those in favor? Any opposed? Attorney Wong, you're the star of the day.
Thank you so much.
Mr. Chairman,
Further business.
would the committee like to not have its continuing meeting?
Yeah. There doesn't
Well,
seem
so
to
I
be
meant-
any
yeah, so-
necessity of that. Any other business?
Well, I always say at the beginning that a conditional amended, so this one was amended. You know, it was conditional.
Thank you all for your attendance, and the meeting is adjourned.
Just one more meeting for this committee.
Okay.